Hello everyone, this is Yatharth and I am here to explain you about the bailment and essential feature under section 148 of the Indian Contract Act. So what is bailment? Bailment means a kind of relationship between two persons where the personal property of one person temporarily goes into the possession of another person. That is to say, where the personal property of one person goes into the control of another person on temporary basis, not on permanent basis. Say for example, delivering of the garments to the dry cleaner, delivering of watch to the wash repair. So here I am delivering my clothes to the dry cleaner. It means that I am giving my clothes into the control of dry cleaner for a specific period of time. Once the clothes get dry clean, I'll get back those clothes by the dry cleaner to me. So here it means I'm giving my clothes for a specific purpose, and that specific purpose is dry clean. Once that purpose is achieved, I'll get back my clothes from the dry cleaner. So this is what is called bailment. Basically, bailment is defined under section 148 of the Indian Contract Act, which says that bailment means delivering of goods by one person to another person upon a contract. Here please pay attention. Here I am saying delivery of goods by one person to the another person upon a contract. It means that to constitute bailment under section 148 of the Indian Contract Act, it is necessary on the part of bailer as well as bailee that there should be contract between both these parties, otherwise there will be no bailment. And once after delivering the goods, it is the duty arises on the part of the bailee to return those goods as per the direction provided by the bailer when the purpose is accomplished. Or sometime it also happened that the bailer gives certain direction to the bailee that instead of giving back goods to me, you can dispose of those goods. So it depends on the bailer whether he is giving direction regarding the disposing or regarding the keeping of goods for a specific period of time. So that is called bailment under section 148. Bailment means a kind of delivery or delivery of the goods by one person to the another person upon a contract. Okay, and once the purpose is accomplished of that contract, there is a duty arises on the part of the bailee to give those goods back to the bailer as per the direction provided by the bailer at the time of delivering the goods, and this is called bailment. Now, under bailment, there are two parties which is a very crucial role to constitute bailment effectively under section 148 of the Indian Contract Act, and those two parties are bailer as well as bailee. So bailer is the one who delivered the goods and bailee is the one to whom goods have been delivered. So here the important noteworthy aspect is that while delivering the goods to the bailee, there is a duty arises on the part of the bailer to give certain directions how to use those goods or how to dispose of those goods or how to keep those goods. There is a duty on the part of the bailer to give all these directions to the bailee effectively, and there is also a duty arises on the part of the bailee to return those goods properly to the bailer as per the direction provided by the bailer to the bailee. So now let's come to the features of bailment under section 148 of the Indian Contract Act. The foremost feature of the bailment is delivery of possession. Delivery of the possession means when we give our goods into the control of another person. Unless and until there is a possession, there will be no bailment under section 148 of the Indian Contract Act. So now let me give you one example for this. If there is an owner of the house and while leaving the house, he gives certain direction to his servant that you are not supposed to leave the house unless and until I come back. So here what the owner of the house is doing, he is giving certain direction that you are not supposed to leave the house. Here please pay attention that there is no bailment on this example. Why no bailment? Because he is merely giving direction to the servant, and the servant is required to fulfill those direction effectively. Yani it means that the servant is not allowed to leave the house unless and until the master come back. He is just merely fulfilling his duty of care towards his master, that is to say by staying at the house. And once the master come back, his duty will also get disposed of. So here there is no bailment, here there is no contract. He is just simply giving direction that not to leave the house unless and until I come back. So that is why here there is no delivery of the possession, here there is no delivery of the goods, and that's why there is no bailment under section 148 of the Indian Contract Act. Okay, so let me give you one more example for this. There was a case before Madras High Court, and the name of that case is Kali Perumal versus Vijayalakshmi. And what happened in that case? There was a lady and she went to the goldsmith along with some jewels for the purpose of marrying them and utilize those jewels into new one. Every day what that lady used to do, she used to visit at the shop and collect those half-made jewels made by the goldsmith. Along with this, she purchased a box, or you can say she had a box, and that lady used to keep those half-made jewels in that box. Now here please pay attention. Why? Because the key of that box was in the possession of that lady. I'm repeating again, the key of that box was in the possession of that lady, not in the possession of goldsmith. So now one day what happened, some of the jewels from that box were lost. So due to this, that lady filed a case before Madras High Court against the goldsmith that this happened with me, so that's why he is liable. But the Madras High Court held that the goldsmith is not liable. Why so? Because the possession of that box, or you can say the key of that box, was in the possession of that lady, not in the possession of that goldsmith. It means that if you remembered, I told you that there should be delivery of possession of goods from one person to another person. Here who is bailer? Here the bailer is that lady and bailee is that goldsmith. But it is necessary to constitute bailment under section 148 of the Indian Contract Act that there should be, that the possession should be with the bailee, but here the possession was with the lady. So that's why the goldsmith is not at fault. That's why she is not entitled to claim any damage from the goldsmith. So now the second feature of the bailment is delivery should be upon some contract. It means that to constitute bailment under section 148 of the Indian Contract Act, it is necessary that there should be some contract between the bailer as well as bailee, otherwise there will be no bailment under section 148 of the Indian Contract Act. Let me give you one example for this. There was a case, and the name of that case is Ram Gulam versus Government of Uttar Pradesh. In that case, it happened that the ornaments of the plaintiff, having been stolen, now were recovered by the police. But unfortunately, what happened? Those ornaments once again stolen by someone else. So now, due to this, the plaintiff filed a case against the state that state is liable for this. But the court held that the state is not liable for this because there is no contract between the state and the plaintiff. They were just merely fulfilling their duty of protection towards those goods. So that's why state is not at fault. That's why state is not at fault, because the state is not bailee. But in case of finder of the goods, there is a bailment. Let me give you an example for this. There is a case, and the name of that case is State of Gujarat versus Muhammad Hassan. In that case, it happened that the goods of the plaintiff were seized by the state under the Sea Custom Act, and the duty of care towards those goods were not effective by the state. So, and the state contended that there is no contract between the plaintiff and the state. So there is no bailment under section 148 of the Indian Contract Act. But the court rejected this view and held that it is not necessary that to constitute bailment under section 148 of the Indian Contract Act, it is necessary that there should be contact between the bailer and bailee. Even without a contract, there can be a bailment. And the view of this court was affirmed by Supreme Court in so many other cases. And later on, in the case of Ram Gulam versus State of Uttar Pradesh, Ram Gulam were granted the compensation. In that case, then it happened that state is at fault. So that's why in case of finder of the goods, the bailer is entitled to claim damages. Now let's come to the third features of the bailment and the last, that is there should be some purpose. It means that while delivering the goods to the bailee by the bailer, there should be some purpose with respect to that bailment. Otherwise, there will be no bailment under section 148 of the Indian Contract Act. And when that purpose is accomplished, there is a duty arises on the part of the bailee to give back those goods to the bailer properly as per the direction provided by the bailer to the bailee. I would like to also make a difference between bailment and sale. Under sale, what we do, we transfer the ownership of the goods, but under bailment, what we do, we only transfer the possession of the goods rather than the ownership of the good. It means that under bailment, the ownership of the good still remains with the bailer. What does the bailer do? Bailer only transfer the possession of the goods for a specific period of time to the bailee. So this is the basic difference between the bailment and sale.